Good evening, everyone, and welcome to another edition of my legal presentation. And Happy New Year's. This will be the first week back since the holidays. I hope everyone had a safe and happy Christmas and New Year's and Hanukkah or whatever we celebrate, and that everyone is keeping safe and well, and that you had a good rest from 2020, which was a bear of a year, and we are happy to be through it and starting anew in 2021. With that in mind, I wanted to present to you today a bit about what one can expect if they are involved in the criminal justice system by way of being charged with a crime. And a former client of mine had a friend that was just charged with a possession of marijuana. They called me up and they wanted to know what to expect. And as I kind of went through this process with them, I thought it might be interesting to share it also with you, my viewing audience, and hopefully you can learn something or two that maybe you don't know. But otherwise, this is just really just expected to hopefully be informative to you, but hopefully also encourage questions and feedback. And I certainly welcome any of your feedback and criticisms and questions. And I often base entire segments on questions people ask me. And if you like what you hear today, please smash the like button. Feel free to comment or share below. And I hope you enjoy it. So you've been charged with a crime in the state of Florida. Here are some of the things you need to know and some of the things that you can expect. Now, if you're facing criminal charges in Florida, the sequence of events that are going to take place in the court system are pretty much going to be fairly uniform from county to county. It's always a good idea to educate yourself on the process so you can make an intelligent decision. And first thing I recommend, and I highly recommend, that you consult with and hire an attorney if you've been charged with criminal charges in the state of Florida. You want an attorney to defend you. Abraham Lincoln is famous for saying that a person who represents themselves in court has a fool for a client. And Abraham Lincoln was a lawyer, and he knew what he was talking about, because you want an attorney who is competent and skilled in legal procedure and in the law to represent you when they're defending your constitutional rights. It really isn't something you should shortcut. You know, if you can't afford private counsel, which can be pricey sometimes, I try to make my prices reasonable for my clients, but not all attorneys do that. There's always the option of the public defender in the event that you don't have the funds to pay for an attorney. And of course, depending on the type of charge, depending on the state's commitment to attempting to incarcerate you potentially, you may or may not be eligible for a public defender, but that's something that the court would have to determine indigency status before they make that decision. So you get charged with a crime. There are a couple of ways that this can happen in the state of Florida. First, you can be, and this is most common, the police can make an arrest and actually handcuff you and take you down to jail in a police cruiser. Now, if the officer is within his discretion and may want to save you the ride downtown, he may then do something a little different in certain charges. He may issue what's called a notice of appearance rather than arrest you, actually physically cuff you and arrest you. He can issue a notice of appearance, or an NTA, as we like to call them for short. So once a police officer has probable cause that criminal activity is afoot, and by probable cause, the definition is that amount of evidence or that quantum of evidence that a reasonable police officer would have to know that a crime is taking place or has taken place. So once an officer is established using a totality of the circumstances analysis, looking at all the aspects of what's going on, if he feels that there is a probable cause that what's going on meets the elements of a crime, the legal elements, then he can place you under arrest. But there are some situations where an actual arrest may not be necessary. First time misdemeanor possession of marijuana, open container of alcohol, sometimes driving with a suspended license, even though it may be a criminal charge on a first time, maybe even a second time, they may not arrest you on it. They could issue the notice to appear, which gives you time and place where you need to show up and answer for the criminal charges that have been alleged against you in the system. The third method of charging people with crimes is when the state attorney files what is called a direct information. Now, after a criminal investigation of sorts has been conducted, usually initiated by police or initiated by the call of a victim, the state then has the discretion to review the information and doesn't have to necessarily make a charging decision right away, because usually these people are not in custody and there's no clock running for them to be taken out of custody. And there's no risk of the state forfeiting their ability to keep somebody in custody. They can do what's called a direct information, where they just directly file against the defendant. The defendant is then served with a notice to appear in the mail, in which case they have to appear time and place that the state tells them to. So those are very, very important things, because those are the ways that a person can be charged with a crime in the state of Florida. Now, if you are one of the people that is unlucky enough to be arrested by the police and taken into custody and not able to bond out the day of or the night of your arrest, within the next 24 hours, usually the next morning or the next afternoon, you're going to go to an advisory or a first appearance before a judge. And that's usually done remotely, usually be in the jail wearing the orange pajamas and possibly the shackles, and you'll be seen on a closed circuit television, and you'll be seen by the judge, who's usually sitting in a courthouse in a special courtroom for that purpose. So once you have been arrested, or whether arrested for the crime, or if you're issued a notice to appear and you don't appear in court, the court can issue what's called a capias to pick you up. You'll be placed into custody, you'll be taken down to the jail, and the next morning you'll have your first appearance and your first advisory. Now, this is just an advisory to answer for the charges that have been alleged against you by the police officer based upon his probable cause. This isn't actually the charges the state attorney has decided to file against you. That comes later. This is just answering for the officer's probable cause finding of your activity as it relates to criminal activity. So at that hearing, the judge will apprise you of the probable cause for which you're being bound over, decide whether or not you're eligible for a bond, have the bond in place either lowered or raised, or possibly release you on your own recognizance, or ROR. And that's generally released to the public with restrictions, often restrictions to limit contact with victims or have no contact with victims, or refrain from certain activities or from going to certain places during the pendency of your case until that order is lifted. And that's not going to be on the day of your advisory, I can promise you that. Although victims are known to show up sometimes and express their opinions on contact from time to time. Now, one of the approaches that I take to criminal cases is, I kind of split it up into phases. The first phase is the custody phase. The first thing I do is I try to get the person out of jail if they're in jail. The second phase would be the charges themselves. Speak to the state attorney ahead of time, try to see if there's any mitigating the charge that could be filed, or perhaps dismiss the charges altogether if I can provide information that would warrant that. And third, after custody, after the charges, the third is disposition, getting the client the best disposition possible. I just look at it that way, and it seems to make sense to people, and it works pretty well. So after you have been charged by probable cause by the police officer, or notice of appearance, notice to appear, or the state has filed a direct information against you, you are now the state can then, the state is then formally charging with it. Direct information is a formal charge. But if you've been arrested on probable cause or an NTA, the officer may have issued charges, and the state attorney is going to investigate those charges and possibly either charge as they've been charged, charge something different, maybe something lesser, maybe something more, or not charged at all if the state attorney decides not to file charges. And understand something, the state attorney is the only charging authority. The judge doesn't charge you with a crime. It is the prosecution, and a prosecutor is an executive officer. He is the bottom of the rung, well, not the bottom, but close to the bottom, with the president of the United States being on the top, the governor being closer to the middle, and the police being executive officers. But as a state attorney, you are actually an executive officer, and you have executive authority to prosecute crimes. And generally, assistant state attorneys don't have as much discretion as they might, but obviously the head state attorney is the one that calls the shots in the county. And as you know, we've all recently mourned the loss of Bernie McCabe, who was state attorney for 8 terms in Pinellas County. I served under him from 1998 to 2002. He was a remarkable public servant, and he certainly was worthy of our respect. And he is now, unfortunately, no longer with us, but his memory lives on, and he will be remembered because he was pretty impressive as far as how he did his job. But anyway, back to what we're talking about. So formal charges are then alleged against you by the state, and they'll do that in a charging document called an information. And it's not an indictment. You're usually hearing, oh, they were indicted on criminal charges. No, most of the time you're charged with a misdemeanor or a criminal information, which is just a document that lays out the offenses that you've been charged with and informs you of them. So it's called an information. That's the paper that's filed against you. Once that happens, the case will be set for an arraignment. An arraignment's a very important stage. It may not be your first appearance before the judge because you might have had an advisory, but it's the first time you'll appear before the court after the state has made its filing decision. So you're then required to appear before the court. The state attorney will be present, and you possibly may not have an attorney, but if you do, typically we'll file notices of appearance and our clients won't have to attend those things. But the purpose of an arraignment is to entertain the plea from the defendant, either a plea of guilty, which means I'm saying I did the crime, a plea of not guilty, which is saying I didn't, or a plea of no contest, which means I'm not saying I did do what you allege. I'm not saying I didn't do it. I'm just not going to challenge the state's evidence. I'm entering a plea as a matter of convenience because I want to dispose of the case in this way. And people may have reasons that they want to do that. It's very, very important. But you can enter at this time, and almost always your attorney is going to file a written plea of not guilty on your behalf, which will probably excuse your presence at the arraignment. And even though you may consider you're guilty, that's irrelevant at this point. Even though you may have no intention of fighting the charge, you plead not guilty because you have a right to, and it won't make the court or the state angry. You have the right to do this. It also gives your attorney the ability to examine your case and look at for its strengths and weaknesses. In fact, when your attorney files a notice of appearance and written plea of not guilty, it's also going to include a demand for discovery, a jury trial demand, waiver of appearance at pretrials, all kinds of things. So while that's all going on, the discovery process is then commenced between the state and the defense, where the state has to share anything that they would use against you to prove your guilt. And the defense actually has a reciprocal obligation to provide the state with evidence it would intend to introduce in trial, even though a defendant has no legal obligation to put any kind of defense up whatsoever. But discovery is going to be reciprocal. So if a defendant wants to use an alibi, he's got to declare the alibi ahead of time, stuff like that. So, and also during this process, the defense attorney can examine the state's case and determine whether or not there would be constitutional challenges based upon based upon admissibility of evidence, which may have been collected in a way that may be in violation of a person's constitutional rights, either the Fourth Amendment, illegal search and seizure, warrantless search of a person or their vehicle. Confidential documents can be taken away. The police can come to your house or your apartment and gain entry without a warrant. And not that there aren't certain warrant exceptions, but that's a little beyond the scope of what we're going to talk about today. But in the event that there is a constitutional violation alleged, then your defense attorney can file what is called a motion to suppress. And the purpose of that is to flesh out the facts that would justify the court suppressing evidence gathered by the state under its constitutional authority, and then basically disallowed at trial as, and basically legal jurisprudence has developed the term fruit of the poisonous tree. So any evidence that flows from an unconstitutional a search where proper police procedure was not obeyed, could potentially, upon motion from the defense, be kept out by the court as fruit of the poisonous tree. So that would not necessarily come in. You see this sometimes in DUI stops and things like that, where also, as far as search and seizure under the Fourth Amendment, there's also statements. If you're not properly Mirandized when actually in a custodial setting, statements that you make to the police when your rights have not been properly explained to you may be excluded, as well as pieces of information. So your Fifth Amendment right is your right not to incriminate yourself, and a motion to suppress can go to Fourth Amendment rights, illegal search and seizure, or Fifth Amendment rights as far as not incriminating, self-incrimination, and that sort of a thing. So, and like I said, the excluded evidence is then called fruit of the poisonous tree. Now, throughout the process, you're going to attend what are called pretrial conferences or dispositional conferences, which we call them in Hillsborough County, where I practice criminal primarily. Those are basically case management conferences, and those are very, very important, because basically the court during a pretrial conference or a dispo will assess the posture of the case. How far along are we? Have we conducted sufficient discovery? Are we ready to set the case for trial? Are we going to try to enter into a plea, or is some other disposition going to be available? And what the options for defendants are several. The state can always dismiss the charge if it decides that it wants to. It usually doesn't when it can prove its case or feel like it can. But if a state attorney has filed a document and information and feels they have a reasonable a reasonable chance of success at trial, then they're going to go forward on that charge. Doesn't always seem intuitive, but they're going to do that. So certain options exist. There is pretrial intervention, which is interesting because this is a program that certain defendants who have minor or no criminal records may be eligible for. It exists in misdemeanor and in felony cases, and recently has sort of been instituted in DUI cases where it normally wasn't the case, because the flexibility of reducing a sentence in a DUI is difficult because of the minimum mandatories. But the state has extended intervention. Essentially, it's informal probation that's run through the state attorney's office rather than the court. So you'd never enter a plea to the charge. If the state agrees to let you on pretrial intervention, then you go through the informal period of probation, you report monthly, you fulfill your requirements, and if you do it successfully, the state then dismisses your case. Now, as far as a plea is concerned before the court and you being placed on probation, you're going to have a withhold of adjudication or a conviction on your record, depending how those things fall out. However, with pretrial intervention through the state, you will actually have the possibility of the case being dismissed and then possibly having your arrest sealed and expunged later on, making it disappear. That only exists with pretrial intervention or dismissal of a case, not after a plea to a conviction, although you can get a seal and expunge if you plead to a case that is withheld adjudication, as long as you have no convictions on your record at all, because convictions will disqualify sealing and expunging. Sorry, there's a lot of information. It's kind of coming out of my head right now, but I'm just trying to make everybody aware. And there are certain parts of this I'm going to break down and explain at a later time, later date. So the pretrial disposition hearing comes up and the judge determines the posture of the case. And it's often necessary to have more than one pretrial hearing. But oftentimes, plea deals are entered into. It's kind of funny. One of the reasons I did this was somebody recently asked me, how are people able to get around the Constitution by entering into plea deals? Well, that's not really what happens. Plea deals are constitutional, and they're necessary because the court's dockets are very, very crowded. And I would say 90% of cases resolve on some sort of plea. A plea is just simply a deal made between the state and the defense, but understand something. No plea deal is entered into without a defendant filling out a plea form, which is explained to him by his attorney, where all the rights he's giving up by entering the plea: right to trial, right to call witnesses, right to have, right to remain silent, and many other rights are explained. Unless he waives those rights, a plea deal is not something that's going to happen. In fact, the courts and the judges go through a very lengthy and detailed colloquy with each defendant, asking them if they understand the rights they're giving up, having them sign the document, and even asking if they're happy with the service that's been rendered to them by their own attorney. So if a defendant is doubtful as to whether or not he wants to enter into a plea voluntarily, or whether or not he truly understands the rights he's given up, no judge in his right mind is going to take that plea at that time. The person's going to have to sit and think about it, or come back on another day and decide what it is they want to do. But plea deals are very, very important. Usually at this point, the state has worked its case up pretty well. The defense has as well, and there is a possibility, based upon the strengths or weaknesses of the case, of getting the case resolved without having to go to trial and risk what a jury may come back with, or a judge may come back with, which may not be what the defendant wants, or maybe not be what the state wants. But either way, a plea gives you the option of controlling your destiny, and that's a very, very important thing in the court system, rather than turning it over to 6 people whose only qualification in life is that they have a driver's license. Just like in a civil case, a criminal jury is pretty much the same thing. So once discovery is conducted, once all plea negotiations have perhaps fallen through, it comes time for trial. and the trial is going to be conducted before 6 people. The state will put its case on. The defense will defend the defendant and either put on evidence or not. It's the defendant's option. There'll be a long jury selection process. There'll be opening statements. There'll be evidence, the state's evidence, the defense's case, if they want to put it on, closing arguments, and then the case goes to a jury. And once that jury comes back with a verdict, it is then within the purview of the judge to issue the sentence. The state may insist upon incarceration, even if it isn't necessarily required under the statutes. And the defense is obviously going to ask that it not be imposed, which is in the best interest of your own client. However, the judges in the case of misdemeanors will probably sentence on the date of trial. In the case of felonies and more complicated cases, they may put off sentencing for a later time. Also, in cases of violation of probation, you may admit a violation and come back for sentencing at a later date, perhaps having been given the opportunity to fulfill certain requirements. But that's essentially how it goes. And obviously, the outcome of a trial could either be a not guilty verdict. It could be a withhold of adjudication if the court wants to hold you responsible and not convict you, or the court may convict you of the crime for which you've been charged. So that's it wasn't as brief as I would have liked it to have been, but those are kind of the nuts and bolts of being involved in the criminal system. It's one of the reasons why you need an attorney. Really is a good idea. So if you've been charged with a crime, call me. The law offices of Christopher DeBarry at area code 727-656-7852, or you can email me at chris@cdbinjurylaw.com. Check out my website, cdbinjurylaw.com. And if you like what you saw today, please smash the like button, comment, and share this with your friends. Thank you very much, folks. And remember, if you have questions, call me, 727-656-7852. Happy New Year, everyone, and thank you.